Good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, March 13th, 2026. We are on voting list number 8, and we are going to start off with Senate Bill number 8.
Senate Bill 8 expands prohibitions under the identity fraud statute, including prohibiting a person from using personal identifying information to cause harm as specified in the bill, assuming the identity of another, including a fictional person, to harm, harass, intimidate, or threaten. The bill also prohibits a person from using artificial intelligence or deepfake representations for specified fraud-related purposes. Finally, the bill authorizes a person who is the victim of specified acts prohibited under the bill to bring a civil cause of action for injunctive or other appropriate relief against the person or persons who committed the act, and makes other clarifying changes regarding related penalty provisions. There is one amendment in your voting packet. That is Amendment SB 8/493123/1. This makes changes on bill page 5, beginning in line 29. So the prohibition under F2 would now read, a person may not knowingly, willfully, and with fraudulent intent use artificial intelligence or a deepfake representation to cause harm to another by impersonating, falsely depicting, or claiming to represent that person or any other person.
So I'm going to adopt the amendment. Okay. All right, the amendment's been moved, it's been seconded. Is everyone okay being recorded in the affirmative on the amendment? Okay, now the bill's before you as amended. Further discussion? All right, so there's been a motion for a favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative on Senate Bill 8 with the amendments? All right, Senate Bill... sure, yes. Senator Sidnor would like to be amended onto the bill as well. I'm going to get on Senator. Looks like the whole committee wants to get onto the bill.
Thanks for the work, man.
Yeah, that was great. That was good stuff. All right, Senate Bill 8, as with the amendment, passes unanimously. All right, we'll now move on to Senate Bill 42, and that is Shamari.
Senate Bill 42 expands existing immunity protections to encompass certain transfers of hydrolyzed and soil remains, more specifically, a licensed funeral establishment, registered reduction operator, or holder of a permit to engage in the business of a crematory who acts in good faith is not civilly liable for transferring the unclaimed cremains or hydrolyzed or soil remains of a veteran or an eligible dependent of a veteran to a veteran service organization for the purpose of disposition. Likewise, a veteran service organization that acts in good faith is not civilly liable for receiving the unclaimed cremains or hydrolyzed soil remains of a veteran or an eligible dependent of a veteran for the purposes of specified disposition. There are no amendments.
No, it's kind of morbid, but
This is an interesting bill. What's your flavor? All right. Favorable has been seconded. Is everyone okay being recorded in the affirmative? This is 42. Senate Bill 42 passes unanimously. We're now going to move on to Senate Bill 61.
Senate Bill 61, as introduced, establishes the Release Preparation Program in the Division of Correction. The division must establish a protocol for registering formerly incarcerated individuals in the program to have access to state correctional facilities for the purpose of assisting incarcerated individuals with release preparation. There is an amendment in your packet. It's number 183220/1. The amendment does several things. First, it renames the program to be the Volunteer Services Program. It requires that the list of volunteers be maintained by the division rather than made available to the public. Volunteers may choose whether or not their names are made public. It removes the provision allowing money from the Cannabis Regulation and Enforcement Fund to support the program. And finally, it removes from the bill a requirement that the Office of the Attorney General approve the protocols.
Let's move the amendment. Is everyone okay with the amendment? All right, now the bill is before you as amended. The motion's for a favorable with the amendment. Further discussion, Ms. Cole? 61.
I have a quick question. I'm looking at F1. If a formerly incarcerated individual does not want the formerly incarcerated individual's name made available to the public, another volunteer or organization may provide that volunteer's name or the name of the organization on behalf of the formerly incarcerated individual. So I like that, they have the ability to say yes or no to have their name public. I like that the department or the Division of Correction has it. I'm not quite sure the part about the organization may provide the organization's name. Could someone explain that to me, please? It's page 4.
Last page, F1. I'm trying to look at the Attorney General's information letter because this was a suggestion that they had made. Let me see. The formerly incarcerated individual does not want that. What's your question again?
I'm just trying to understand F1. That, if they don't want their name made available to the public, another volunteer or organization may provide that name or the name of the organization on behalf of the individual. So an organization may provide the name of an organization?
So I guess if you're a part of, I'll make an ABC organization, you don't want your name published, the way that I think I was told is you would be able to put ABC organization so that the public would know who's a part of this program. They will be able to go over to ABC organization and if there are any questions or whatever.
Just received this recently. I think essentially what it's saying is sort of, you can. Okay, so I think the way I read it, I think, is that essentially you can have sort of someone provide a name like as a representative. So the formerly incarcerated individuals want their individual name on there. They could have, the organization or perhaps a representative at the organization sort of be the, it could be like an intermediary, like if, you could talk to this person who could then get in touch with the formerly incarcerated individual, like basically they would have a representative provide their information rather than, their own information.
Okay, and this is what's provided to the Division of Correction?
Correct.
Okay, thank you.
So all the relevant stakeholders have been consulted on this language. I just want to put it on the record. And so if they're fine with it, then I'm good. All right, the amendment has been moved, it's been seconded, it's adopted. Now the bill is before you. As amended, there's been a motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 61 with the amendments passes unanimously. All right, so we're going to move forward with Senate Bill 111. Okay. Said, for which one?
For this, I don't know if we adopted it.
Oh, got it.
We did.
Yeah, understood.
We adopted 763927/1, and then we added in section 12, 110, 411 to.
So Senate Bill 111 requires the Motor Vehicle Administration to engage in a specified process to facilitate compliance with state vehicle registration requirements when the administration has probable cause to believe that a vehicle owner is a resident of the state but has failed to properly register the vehicle and display proper registration plates. So the committee considered this bill a couple weeks ago and adopted an amendment. I think what we're going to do is reconsider that vote because there's an entirely new amendment in the voting packet. So I think we have to make that motion.
So there's a motion to reconsider the vote by which the amendment passed. Is that a
Well,
second?
no, I think we're removing the amendment.
Yeah, we're removing the amendment.
Yeah, so just.
So seconded, everyone's okay doing, all right.
So there is a new amendment in your packet. It's number 143829/1. It does several things. It allows the administration and parking enforcement agents to take possession of certain illegally displayed out-of-state registration plates. It incorporates the provisions of Senate Bill 173, which is an administration departmental, which allows the administration to enter into agreements for the reciprocal enforcement of automated enforcement violations. The amendments exempt trailers from required to be registered in the state. They would still have to be registered in a state, but they would not necessarily have to be registered in Maryland. It exempts certain vehicles that are being re-registered in the state in order to comply with the requirements of the bill from having to pay certain excise taxes. And they also prohibit tag and title companies from selling or offering for sale out-of-state registrations.
All right, so we're gonna move the amendment, and then we're gonna strip something out off of the amendment. So, and there's further questions. So, okay, excellent. So everyone's okay with adopting the amendment. Okay, now the bill's before you as amended. Senator Walsh-Reicher.
It appears, and thank you to Senator Henson, it appears that there's an error in the bill. We very purposely struck on the page after page 2, there's new language that says the administration shall suspend the license of a person if it finds that the person violated 15606F. Oh, no, that's, okay, I'm sorry. That's not what, it took me a second to realize what's happening here. This is not the driver's license. This new language is to suspend the license of tag and title companies, not the driver's license, the business license of tag and title companies that violate the law. So I'm sorry. Thank you for catching it. I misunderstood what was happening here, and the language is not in error.
I just want to make sure I'm not missing something here, because when in the original bill, and Josh, correct me if I'm wrong, but or just make sure I'm seeing this accurately, we specifically mentioned the registration type G. Does that language correspond with having that carve out on, I guess it would be page 5 of the amendments at line 15. Is there someplace else I'm looking for where they actually strike out registration type G?
So it doesn't refer to G specifically, but it's in 2 places if you're on the reprint. On the second page of the reprint at the bottom there, you can see it's striking the requirement that trailers, semi-trailers, and pull trailers be registered under the subtitle. And then 2 pages after that, at the top of that page is adding a new exemption to the registration requirement, which is a trailer, semi-trailer, or pull trailer that displays valid registration issued by another jurisdiction.
Mr. Chair, if I can just have your indulgence for 1 minute. For some reason, I remember seeing or thought I saw the type G registration. I just want to look real quick, if I can, to make sure I didn't miss something.
So, yeah. Correct, and the reason, I mean, so the type G registration remains in Maryland law because you can still register the trailer in Maryland.
Yes.
It doesn't necessarily have to be Maryland, so it remains a registration type in Maryland.
Yes, perfect, thank you. Thank you.
All right. Now the bill's before you as amended. There's a motion for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 111 passes unanimously with the amendments. All right, we're now going to go on to let me get to you, Nick. Where's your thing? Senate Bill 352.
Senate Bill 352 requires the Motor Vehicle Administration to develop and make available an old line plate for certain vehicles. The old line plate must resemble the plates issued by the state for display on a motor vehicle in 1911. The bill establishes requirements and limitations related to the issuance, specifically through auction and transfer of such plates. So the committee considered this bill at a previous voting session and adopted a amendment which modified the title. There is an additional amendment in your voting packet, which is number 363-326/1. This amendment concerns the distribution of revenues that are raised through the auctions. So under the amendment, after cost recovery by the administration, the distribution would be as follows. 50% would go to the Transportation Trust Fund, 30% would go to the Department of Social and Economic Mobility Special Fund, 10% would go to the Chesapeake Bay Trust, and 10% would go to the Maryland Agricultural Education Foundation.
All right, the amendment's been moved, it's been seconded. Is everyone okay being reported on the amendment? Okay, excellent. Senator James has a question
Yeah,
on the amended bill.
just because I guess we're all familiar with the Bay plates and the ag plates. I don't know if I've ever seen us use plate money for anything other than, you know, the specialty organization transportation issue. So maybe we could just discuss that very briefly. But I also think I recall, this is a one-time, isn't this sort of like a limited edition auction thing? So this would not be in perpetuity. It would be this singular event So if somebody could just explain, because I would have some trouble starting to use plates outside of the arena of transportation for a number of reasons, including public buy-in. The public support for these plates, they know that the money's going to the entity for which the plate is, being displayed. And I don't think the public, I'm not sure where the public would be on this. So that's sort of the gist of my interest.
Now, so I think it's a limited sale because it's a limited number of plates that'll go through auction. That money will then go into, obviously, to these pots here. You're right that generally speaking, the money that like specialty plates go for a certain cause or something like that. So that's why I think the senators brokered a deal to make sure that some of that money went to some of those specialty, like the Bay plate, Chesapeake Bay Trust Fund, and where else? The Agricultural Education Fund, and then the rest goes to the TF, right? Transportation Trust Fund.
50 goes to TTF and
Yeah.
30 goes to something else.
Yeah, so that's, yes, but then if they're resold, those are private sales. So once they're gone, that's it, that initial money goes into these three buckets, and then that's it.
And then,
it's-
just to follow up.
4 buckets.
The Department of Social and Economic Mobility Special Fund, what is that? What is that? Is that new?
That's the new agency that was created last year through legislation.
What does it do?
It holds the MBE program for the state, all the social equity mobility programs that the state has. It's the agency handling that.
And then, just confirm with me that this will be, is it a one auction of all, like a one auction, or is it a series of auctions? And how many plates are we talking about?
So it's up to the administration. They'll establish and operate the public auction program themselves and award registration numbers from that. But it'll be up to Department of Motor Vehicles based on the need and what they see.
Right, but it'll be one auction, I'm sorry.
It's up to the Department of Motor Vehicles.
So it may not be, it could be an
It could be
ongoing?
more than one, yes.
It could be ongoing?
It could be ongoing, yes.
Okay. All right.
So now the bill's before you as amended. There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Senate? I'm not, just okay. Excellent. This is 10-1. Senate Bill 352 passes, with the amendment, passes 10-1. All right, we're now going to go on to Senate Bill 661. That's Jamie.
Jamie, let me know when you're.
Senate Bill 661 authorizes the district court or a circuit court during a criminal trial or hearing to receive into evidence an intercepted wire, oral, or electronic communication and evidence derived from it, regardless of whether the disclosure of the communication would violate the state's Wiretapping and Electronic Surveillance Act if specified requirements are met. Even if these requirements are satisfied, a court may not receive the communication and evidence derived from it into evidence unless the proponent gives the adverse party notice of their intention to offer the communication and evidence and provides the name and address of the party whose communication was intercepted. Notice must be given sufficiently in advance of the trial or hearing, but not later than 14 calendar days before the trial or hearing, to allow the adverse party a fair opportunity to prepare. There's one amendment in your voting packet. This is Amendment SB 661/603-729. And this makes changes on page 2 of the reprint. Oops. Page 2 of the reprint, and would strike the applicability to cases that involve hate crimes under Title 10, Subtitle 3 of the Criminal Law article. Instead, the bill would apply to a case in which the communication is offered involves a crime committed against at least one individual.
Been a motion moving. Senator Henson has a question.
Do we, I want to understand, are we moving to one-party consent, or, I just want to get my bearings in turn. I apologize that I didn't work group, or I'm reading it now and trying to decipher what's happening.
Sure. Couple of things. This bill, as it is, it was the chair's bill last year, and we passed it out unanimously. It does not touch in any way one-party consent. What it does is basically, it's like an exception to the hearsay rule. The judge can allow the evidence in or not, but it doesn't change. And we had testimony that it would still be subject to the two-party consent rule, and if the state's attorney wanted to put that in, they would have to grant immunity to the witness. So it doesn't touch our two-party consent rule. It just allows the evidence to come in if a judge determines that it meets these criteria.
And the original drafting before the amendments that are being considered, has it drafted as involves a crime against at least one individual? So that is any crime. If you trespass, I guess, no, that's a property crime. If you assault second degree, any sort of crime against another person, if you threaten a person, harass a person, intimidate, anything that one person does towards another person, that's when we would permit the evidence to come in. It's not specific crimes of violence, or it's any crime against another person.
Counsel, you want to take that?
Right.
Yeah. I think the distinction that's being drawn there is crimes against people versus crimes against society, or where there is no actual victim. In a, I don't know, I'm thinking like a littering case, if you're, walking down the sidewalk, that would be an example where I can't think of a victim. Drug distribution or use, I don't see a victim in that case, but if there's an assault, obviously there's a victim. So I think that's the distinction that's being made there.
What about things like, I don't know, identity theft? If it were
Right.
something that were totally nonviolent in nature, does it apply to things of that nature as well?
I'm sorry, I didn't catch.
Does it apply to things of that nature, like identity theft, a crime against a person? I steal your identity,
Sure.
and it's not violent, but I then want to make, I want
Right.
those
Yeah,
statements.
I don't think that it would need to, that you would need to have any evidence of violence. It would
Okay.
just need to be a crime involving or committed against at least one individual.
I'm sorry, I understand. I
So-
think when it's crimes of violence, Mr. Chair, I totally understand. We want to be able to make sure, because there's a public interest in keeping everyone safe from those offenses. And having said that, if the committee wants to move forward with the bill, that's totally fine. I voted for it last year. I'm fine to vote for it this year. I just wanted to understand for clarity. And then I saw hate crime was in there, and that we had stripped that out of the bill as well to go back to the original language. I just wanted to understand the intent, but I voted for it last year, so I'm totally happy to stick to that vote.
No, I think you bring up a very good point, and look, I would characterize it as a carve-out from the two-party consent. I mean, because we are a two-party consent state, and this is a one carve-out or an exception to that, to our rule. And we will later entertain another bill that Senator Sidnor has, which is, I'm very protective of the statute, and so like we are kind of carving out here. And so, but this bill in particular was made for a very limited set of circumstances, and so I do want to take another look at the very limited set of circumstances that this is supposed to address. So I'm going to just hold the bill while I just confer with counsel a little bit more, and then we'll come back to it. But and the same thing with Senator Sidnor's bill, which is a similar exception, but for fair housing purposes, for investigations for fair housing. So it's a different area, but yes.
You're looking to hold the bill, but can we just at least hear what the concern is that she has, so
Sure.
that council can look at that as well?
Yes, Senator James.
I just want to clarify, because I supported this bill along with my bill about second-degree assault. witness intimidation. But I just want to make sure that with the amendments, even though this is wordy, what you're repeating after you explain that it's against an individual, the rest of that language, that is you describing how it would come in as a hearsay exception. Is that what I'm understanding the rest of that language? Because that's what Senator Love indicated, which I am supportive of if it comes in as a
Right,
hearsay
so-
exception, which means it does have to go through scrutiny. It has to meet, Senator Henson's bringing up, it has to go through some scrutiny by the court and, you know, so.
So I don't have a
side.
side-by-side for you. I think maybe where it falls relative to the hearsay exception is that I would say the language is modeled off of the hearsay exception, but
Okay.
this is still an exception. You know, when you think about the wiretap statute, you have the criminal prohibition, but you also have inadmissibility of evidence that was obtained in violation of it. This creates an exception to the admissibility piece under the wiretap statute.
So we're going to take a little break, so that would give me a chance to kind of look at how this is going to work. Because so I would not be quite accurate, no offense to Senator Love, wouldn't be accurate for me to say we've created an exception to the hearsay, because then it would look like it's in the rules and it would be a hearsay exception. This is modeled after it, but let's not call it, because I took you literally. Well, okay. So anyway, we're going to take a moment and maybe you could help walk me through this about how it would work with the hearsay exception and how it's different, because those protections are important. All right, thank you.
So I just want to understand this. So I just went back and looked, and obviously through discussions with the senator, I'm in support of the design behind this bill, but I just went back and looked because I wanted to be sure that it was capturing those specific things that we were looking to protect, that I thought we were. And because I had introduced this bill in 2023 and 2024, but in the language in mine of 2023 specifically addressed that that it would basically, it was allowed to be the electronic oral communication when the person reasonably believes that the person is in imminent danger of becoming the victim of a crime of violence, stalking, abuse under the family law article, or a violation of a protective order under the family law. So those are the four tenets that I thought we were trying to capture in this. And so this one is, it's much broader, in my opinion, than what the focused intent of domestic violence, stalking, and protective orders that we're trying to really protect, in my opinion. So I just want to be sure that the body understands, like, I believe that the design of what we're trying to accomplish is the same thing, but we have slightly different language in talking to the sponsor. And I think that that is the only language we should probably look to pierce the veil of the two-party consent with those very specific crafted elements into it. And that's under the legislation of my 2023 version. Okay. Yeah, it's the 2023 version of SB 749.
Yeah,
Thank you, thank you.
Absolutely, let's take that.
yeah. That's the,
Now, I have a question in terms of, like, this is for the sponsor of the bill. So this is to protect those that are going through domestic violence issues or any issue, right? If you capture. That's the goal. What if I had a case with somebody that I've helped out before, and they had someone who said they did domestic violence, that this person threatened to shoot them, they had threatened to do these things, but the person didn't. He actually had a recording in his house. and his ex had tried to remove the camera out of the house, and then he replugged the camera and it actually captured. Would this actually equate to that, where he'll be able to use this in court to protect himself against claims of domestic violence if that didn't take place?
So he could attempt to use it, and then the court would look at it, and it would go through the C2, 3, 4 in here, and 5.
Okay. C2, 3, 4, and 5.
Contents of the communication and evidence derived are offered as evidence of material fact, not made as part of a furtherance of an investigation conducted by law enforcement. They're more probative on the point, and interest of justice would be best served. Yeah, that could be offered.
Thank you so much. This is a great bill. Thank you.
Thank you.
Thank you. No, I was just going to say that it is broader than what Senator Folden said, but honestly, I don't mind it being broader when you're talking about crimes that are being recorded. I have no problem with that. So I just wanted to make certain that that's said before we go tinkering too much. We're talking about the admissibility of an evidence of crime. Why we would want to protect or stop that from being admissible, or at least having the court look at it. I would say let's think about it before we go tinkering. And I think the amendment, it would capture, I guess, the hate crime that was taken out if it's against one individual. So I'm perfectly fine with how it is. I just wanted to make certain I said that.
So just following up, Mr. Chair, comparing the language that's in the bill to the general hearsay exception, referencing Maryland Rule 5803B24, which provides, this is your basic catch-all hearsay exception. Under exceptional circumstances, the following are not excluded by the hearsay rule. A statement not specifically covered by any of the hearsay exceptions listed in this rule or Rule 5804, but having equivalent circumstantial guarantees of trustworthiness if the court determines that A, the statement is offered as evidence of a material fact, B, the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts, and C, the general purposes of these rules and the interests of justice will best be served by the admission of the statement into evidence. A statement may not be admitted under this exception unless the proponent of it makes it known to the adverse party sufficiently in advance of the trial or hearing to provide the adverse party with a fair opportunity to prepare to meet it, the intention to offer the statement, and the particulars of it, including the name and address of the declarant. So it's not exact, but that's why I would say it's based around the general hearsay exception. Substantially similar to the requirement under the Maryland rules for admission of hearsay under 5803B23, sorry, 24.
Clear, but because when you do a minor change, the court does not know.
Right.
What are we trying to do? Are we trying to do hearsay but with a few adjustments? Is that why the words are different? Or are we trying to be identical, in which case they would say, why didn't you do it verbatim? And I don't know if the language difference is because of just the way you're drafting a sentence or if there's anything substantive, but depending on what you all want to accomplish, but.
Ms. Jordan, do you have an opinion on why the language differs slightly?
Yes, sir. The language differs slightly in that it requires that the recording not be made by law enforcement, because we wanted to be very sure that law enforcement still had to go through the wiretap process. Any other difference was purely stylistic, and my belief is it's exactly the same, other than the law enforcement.
No, the court wouldn't know that.
So as we kind of come together to fix this language, which I support the underlying bill and I voted for it previously. So the language in the bill does not require a weighing against prejudice to the defendant, right? So I don't practice in Maryland, I practice in the federal system. Rule 403 requires a weighing of the probative value to the prejudice against the defendant. That's an appropriate weighing that courts are used to doing. And so I agree that this should come in, but it has to be weighed just like any other piece that has to be weighed. So as we're fixing the language in the bill, I think that weighing test that is traditional in every rule of evidence, I presume there's a Maryland equivalent, we might need to add.
Yes, thank you for that. I agree with you, Senator Walsh-Checker. However, although I may not remember the number exactly, I believe it's Rule 403 requires that background weighing test for all of this. So that's already background noise. Certainly it wouldn't hurt to put it in twice, but generally I think we discourage having it in two places at once.
Add evidence statutorily. That's what I agree with you that I'll defer to counsel, but it's probably wise to put in the statute so it doesn't look like we are.
I have no objection. I just want to be sure you knew that that is background. It's always there.
All right, we're going to hold the bill for now just to work on it, and we'll move on to another bill. So this is make sure we get this one right. So let's go on to Shamari with Senate Bill 477.
Senate Bill 477, subject to specified exceptions, establishes a statute of limitations for a civil action for damages against a person for an alleged act or omission related to the performance, review, supervision, or management of a real estate appraisal, regardless of whether the appraisal is in connection with the federally related transaction. Civil action which the bill applies must be filed within the earlier of 2 years after the date the complainant knew or reasonably should have known of the act or omission, or 4 years after the date when the performance, review, supervision, or management of an appraisal as applicable was provided or should have been provided. The bill applies prospectively only and may not be applied or interpreted to have any effect on or application to any cause of action accruing before the bill's October 1st, 2026 effective date. There is an amendment in your packet. That's Amendment 493520/1. Amendment 1 is technical and makes changes to the title and purpose paragraph. Amendment 2 extends from 5 to 12 years the retention period for appraisal reports and all supporting data that the appraiser assembles or formulates to prepare an appraisal report. It extends from 2 to 12 years the limitations period for a civil action alleging a discriminatory housing practice related to the appraisal of residential real property.
Shamari and I needed to talk through the one amendment, because the only thing that's not in here, I see we increased it from 5 to 12 years on the maintenance of records. The only difference was, I know we had originally agreed upon having the records uploaded onto the land record site so that you have access to the records, and I don't see that in here.
Yes, so typically, land records deal with changes in title, and this amendment, by extending the retention period, would capture all the civil claims envisioned by the extension of the statute of limitations. And so that was a drafting decision I made, but we can make that change as well. So,
Well,
go ahead.
my rational reason for putting the documentation onto the land record site is to have actual track records of this information. And it'll be available for all those if you need to file for a lawsuit later on down the road, because you now actually have access to this information in perpetuity, the same way all records are on land records website.
So the appraisal report, or what's under the record keeping requirements that the Commission on Real Estate Appraisers sets, are much more extensive than what would be feasible to require in the land records. There's some issues potentially, and I know there would be opposition from clerks and other people involved with recording. It would just be a big ask, I think, in my opinion, as well as the amount of information that would have to be entered into the record. But of course, that is something that we can discuss, or I can explain offline more.
Yeah, I was just gonna say.
If they're there, I'm sure you still have access to it's housed.
So the bill requires the appraisers to retain all that record. Already under current law, they're required to maintain them for 5 years. And so it made sense to extend that to 12 years since we're extending the limitations for the
If you wanted to
discrimination.
get those records, how would you get those records? You'd
Go to the appraiser or the
Yeah.
commission.
It's,
Makes it a little bit more difficult to get the information.
there's been a lot of concessions made. He worked with you.
There's no way we can have a short conversation about the propository. I mean, that's a big, heavy lift. That's gonna require the courts to be doing a whole, it's, the fiscal note and all that, I mean, that would be something to come back next year for. And I wanted to work with you, but looking at the high bar, so, I mean, I can withdraw the bill or whatever if it's not ready to go or whatever, but I understand what you're doing. I'm trying to work with you.
No, and I appreciate it.
And look, the appraisers, I've reached out to them. They're not too thrilled about, well, they're really not thrilled about going to 12 because they're only at 5 right now. But I tend to believe it's the right thing to do and to take care of fair housing problems and that kind of stuff. So, look, so.
Thank the bill sponsor for the really thoughtful amendment, and I hear the concern expressed about the records. It would be hard and impractical in some ways to have those recorded with the other instruments. It would be similar to taking the underwriting documents of a mortgage report, and to record those as well. I hear what you're saying completely about having the thread of those if you wanted to be able to see what other people's appraisals were and to be able to use them as evidence to prove the biased behavior in your particular one. But you would still have the discovery process in a lawsuit to be able to get that information when you need to sue, not as readily accessible as having it as a public document, but it would be very hard for the clerks to be able to put that out there and maintain it. You probably would also run into some proprietary information about, some things as well if we were making them public documents. So if to revisit it in a future year might give us an opportunity to look at what happens there. But I think you and the bill sponsor have done so much great work on this amendment. It would be a shame to lose that great work in the place that we are at right now for an issue that you rightly raised as a real issue and something that we can tackle in a really meaningful way with what you guys have put together with this amendment. I would move the amendment.
Thank you. I just want to ask, where else, and I guess Shamari, where else do we have a storage of 12 years for something that's never even, like, I mean, your IRS records, your tax records, how long you keep those, 7 years?
Something like that.
Is what they say?
Yeah.
So where else do we do 12 years?
So there are actions on specialties, contracts under seal is the main part. That's also in the same.
But that's a contract under seal, not someone coming out and doing an appraisal, which is not binding to anything other, I mean, because people get appraisals for a refinance or, you know, I mean, we get appraisals that are done that there's no action on a buyer or seller. They just have it done as an appraisal. So I just have a hard time trying to balance the idea that a contract under seal, 12 years, and now someone coming out, and I'm not undervaluing this, but it's someone's opinion based on the market around them and the features of the home. So if there's, is there anything else that would be remotely like an opinion of someone's that we store for 12 years?
So there's different record-keeping requirements for different business professions. That's not necessarily a statute of limitations.
Yeah, but are they in the statute? Where do we codify someone's record retention up to 12 years in a statute?
I wouldn't be able to say offhand without looking that up. I can look into it.
I mean, I think it's important. I mean, a sealed contract is something that I think should have some type of longevity, but 12 years is a long time to hold on to. And then if I'm reading it correctly, is it 12 years? Oh, it's to the delivery of the client. So, but just 12 years is just seemingly a really long time, because I then had questions about the 4-year window, but my main focus is the 12. So if we can find that out, I just don't think that, I mean, I know they're trying to find a balance to move forward in unison here, but I just have a hard time holding on to something for 12
So
years.
as to the 4-year, that would just be for all other claims not involving discriminatory housing practice.
Okay,
And so those would expire
Okay.
after the 4 years.
thank you.
We're trying to take in the concerns of fair housing violations, and that would only take care of these. The others would be at the 4.
And I appreciate that we're trying to balance that. And if we've got that at 4 years, we have 2 years from the date that the complainant knew or reasonably should have known, which is something that can be subjective at times, depending on where they are in that 2-year window. And then the 4 years, I mean, I don't have a problem with that. Where I have a problem with is that we're looking at codifying in statute 12 years that a professional has to hold on to. I mean, the federal government doesn't require us to hold on to our tax records for more than 7. And we're putting 12 on an opinion that doesn't even, it's just their evaluation of it. I just have a hard time with that. But I understand the real intent behind it, and I respect that, but I have to disagree with the 12-year terms. Thank you.
So business, there's certain records that regardless of what the law says, they will hold them into perpetuity. Even if the statute did not say to hold a specialty for 12 years, a business is going to hold it for 12 years because they know that they have the possibility, they have the liability out there for 12 years. So, and I mention this because I think the initial thought was 10 years, and I'm like, well, 10 years, there's nothing that ties, nothing quite like that. 12 years is something that businesses that enter into specialties, they do. So it's not out of the realm to hold a document for 12 years. So that's where that came from.
I understand your concern. Since the IRS, they can't go back more than 7 years, would you be amenable to changing it to 7 years?
I think that's best. I'm willing to listen. I wanted to hear from some of the other senators about, their take on it, since we had some work group discussions on the bill itself. And I want to publicly thank Senator McKay for working with us on this bill and coming up with some concessions. And if it's the will of the body, that the 12-year keeping of the records works until we can come back and address it at a later date in terms of holding files in perpetuity online and figuring out that way so we can go through a real larger discussion next year. The whole purpose of the work group discussion was for us to not have to put the bill in next year and address it now. But if, like I said, if it's the will of the body, I'm willing to move forward with it so we can take the great amendments that we have made to address some of these issues, but it does not close out the larger picture, which is longer record keeping of this information in perpetuity, so that folks can actually see what's been happening over time. The same way you can go onto the land record site and pull information about mortgages and so many other things. I want to make sure you can do that with the appraisal documentation as well, so that we can protect a lot of our homeowners, a lot of the black community who has been impacted by appraisal bias. It is constantly happening. And so I want to make sure we protect it. And so once again, thank you to Senator McKay for working with us and locking in this 12 years, and then we can work on something next year.
I don't disagree with Senator Henson's assessment, but in listening to, again, what you're saying is the purpose, which is ease of access to maybe someone that may have a claim, something that if there are issues with putting it into land records, I get that as well. There could be some sort of a duty of that appraiser to, on demand, supply them to whomever has an interest in that appraisal. I mean, whomever the homeowner was who had it appraised, something like that. I mean, if you're concerned with access, but they would already have access to it, though.
Yeah, whoever got the appraisal has.
I'm trying to figure out. your. But again, I think she has a point.
No, that's why I agree. I don't want the good work to go to waste, but there's still a hell of a lot more work to do on this issue.
Yeah, I was just gonna say, like putting on the record, I'll work with you to address that concern. I just think it's a bridge too far by putting in the repository at this point without having other people weigh in, so. But, whatever.
The movement's been seconded. Yeah, so the bill's before you as amended. What's your flavor? Is your motion? Motion's for favorable with the amendment. It's been seconded. Do we need a roll call? Or is everyone okay being recorded? Senator Fulton is down.
I'm down. I just want to explain.
Yeah, of course.
I want to explain my vote because there's very specific examples that the senator for Prince George's gave are talking about mortgages and land records. Those are recorded contracts. There's a completed sale and exchange of service, and that's entirely different than someone coming out that you're paying to come out and give an assessment of the valuation of the home. So I think that because of that, I'm gonna, and we've expanded this to 12 years. I can't vote for something like that when there's nothing else, there's nowhere else in the law that we do that. And if they want to hold on to it in perpetuity because they're professionals and they believe that, great. But I think that there's a reason that we've gotten 12 years is beyond a reasonableness, in my opinion. So with that, I'll be voting no. But thank you for the discussion.
Respond to the great senator, over there. But no, and it's a contract as well when there is a service provided for a cost. You know, if I'm asking you to come in to do an appraisal on my property, I've contracted you to do that work, and you're providing a service that I'm paying for. And so that same service is something I believe should be kept, record should be kept for that as well. So that was that.
I'm going to vote for the bill because I do think we should make some adjustments here. But I do want to just support what Senator Fulton and others are saying, because there are various reasons appraisals are done, and this is a very broad approach to something that I think is more finite and limited. So I hope we come back and revisit it. So it's certainly I'm going to vote in favor as a courtesy and be supportive, but I hope we might come back and look at this and fine tune this, as appraisals are acquired for numerous reasons, and I don't know if we really understand all those reasons and how much of a burden we may be putting on individuals and professionals in this arena. But I will be supporting yes for the moment. I hope we revisit some of the policy issues.
All right, Senate Bill 477 with the amendments passes 10-1. All right, we're going to go on to let's go to Senate Bill 471 real quick. Just 471. 471.
Senate Bill 471 alters the maximum annual salary that the Board of Public Works may set for the clerk of each circuit court and a register of wills from $146,500 to the salary of a state employee at grade 26, step 20 of the state of Maryland Standard and Bargaining Salary Scale. The bill also repeals an obsolete provision establishing a minimum annual salary of $12,000 for the Register of Wills in Baltimore City. Pursuant to constitutional requirements, the salary increases for the clerks of the court and the registers of wills take effect at the beginning of the next term of office.
All right, there's a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 471 passes unanimously. Are we going to do the motion withdrawn for Senate Bill 676, which is on page 3? Seconded. Is everyone okay? All right. All right, Senate Bill 365.
Thank you, Mr. Chair. Senate Bill 365 repeals the requirement that the Secretary of State Police, by regulation, stagger the terms of the certification of security guards. It requires the certification of security guards to expire on the last day of the certification holder's birth month rather than the date the Secretary of State Police sets. It repeals the late fee for applications for the recertification of security guards and repeals the requirement that licensed security guard agencies or security guard employers notify the Secretary of State Police if a certified security guard no longer satisfy all of the criteria for certification as specified in the bill. There is one amendment in your voting packet. That is Amendment SB 365/463-926. And that is making changes on bill page 3, and we are just returning language that was previously being taken out by the bill. So let me just get the lead-in language here for you. 28 and 33. So this would strike the, or return the language that provides at least 90 days before certification expires, the licensed security guard agency or security guard employer shall submit a declaration to the Secretary under penalties of perjury stating whether it knows that a certified security guard who provides security guard services on the security guard agency's behalf or for the security guard employer no longer satisfies all of the criteria for certification. So they would need to submit that declaration.
So move the amendment. We're going to move the amendment. Is everyone okay with the amendment? All right, now the bill is before you as amended. Discussion? Sure. Senator Fulton.
We just did something with security guards and moving them under the state police or something in recent years, didn't we?
Right. So now security guards are regulated by state police. Last year there was also, that was 2 years ago actually.
Yeah.
Last year the General Assembly passed legislation that allowed security guard agencies to apply for their employees to become SPOs under certain circumstances. So this space has had some recent development over the last couple of years.
So is this expanding or is this narrowing back from what we did 2 years ago? This is narrowing it back?
Are we on 365?
Yeah, we're on 365.
Yeah.
Oh, it doesn't expand or narrow. It simply makes the recertification process more efficient.
Okay.
Yeah.
All right.
It's a logistical
So it just
bill.
gives like clarity on the
Yep.
proper way to, okay, thank you.
All right, now the bill's before you as amended. Its motions were favorable and seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 365 passes unanimously. All right, let's go on to Josh. We're going to hit you with a couple here. So the Senate Bill 698.
Senate Bill 698 prohibits a person from operating or towing a vehicle without first removing any accumulated snow and ice that poses a threat to persons or property from exposed vehicle surfaces. A police officer may only enforce the violation as a secondary offense, except when the violation contributes to an accident resulting in property damage, death, or serious injury. Violations are subject to specified fines, which increase for repeat offenses. The violations involving commercial motor vehicles also have higher fines. There is one amendment in your packet. It's number 693420/1. It modifies the prohibition to instead be on operating or towing a vehicle without making reasonable efforts to remove accumulated ice or snow from exposed surfaces. It creates two exceptions to the prohibition. One, where compliance would cause the operator of the vehicle to violate safety laws or regulations. And two, where compliance would threaten the operator's safety. And finally, it provides that each day that a violation continues is a separate offense. However, a person may not be found to have violated the prohibition more than once in any 24-hour period.
So just move the amendment, and then we'll just work off the amended bill. All right. Sorry, the amendment's adopted. Senator Love.
Quick question. So the, under B2, it does not apply if it would threaten the health or safety of the operator of the vehicle. So my car's kind of tall, and I do the best that I can to get everything off, but sometimes I can't reach all the way up there, and it would threaten my health or safety if I had to climb up on top of the car to wipe it off. Is that okay? Or am I still in trouble?
Yeah, I mean, I think it would be kind of a totality of the circumstances kind of analysis. I mean, especially if it, there's inclement weather and you would have to, I don't know, get a stool and stand on it. That sounds like something that is potentially threatening to your health. So, I mean, I would caveat just that it depends on all the circumstances, but I think that is the kind of scenario that the amendment is contemplating.
Got it. Thank you.
Now the bill's before you as amended. There's been a motion for a favorable. Senator James has a question.
I have a quick question for clarification myself, because I've certainly experienced, and it's frightening to be going down like 695, 95, and a car in front of you, the top of the snow just comes and hits you, and I've seen windshields cracked. It's very scary. I can't believe people do this and don't make a good faith effort. But is this just operationally, this is law enforcement would be issuing these traffic citations? Is that it? And so I just want to understand. So it would be a police officer, is watching you drive by and they see a considerable amount of snow on your car and they go, okay, that seems like too much snow for me, and pulls you over. Just operationally, just how does that,
So it's
and how
unless.
much is too much snow?
Yeah, so unless it contributes to an accident that results in property damage or injury, it's a secondary offense, so you could not be pulled over specifically for this. I mean, what might happen is, you're pulled over for, whatever it may be, and then, the officer looks and sees, that there's snow on the exposed surfaces and makes that determination at that point.
And I'm
Now-
not trying to micromanage, and I get that. So, but then it's just a reason, it's a judgment call. What the police officer would determine would be, as like Senator Love said, someone my size too might not be able to get up on the, get the roof. I know I can't get the snow off the roof of my car. I get somebody else to help me. But that would just be the law enforcement officer would make a judgment call as to whether he thought that what appeared to be presenting a potentially dangerous circumstance.
Yes.
So that's when you get that ticket. Or there's an accident, and then you could be charged in that particular accident if snow came up, like I indicated, and it went back and hit somebody's windshield and caused damage and whatnot, then that would be another way you would charge somebody under this.
Right, that's where it could be, you wouldn't have to have another violation
You would
necessarily.
not have to have another.
Yeah.
All right, thank you very much.
All right, so there's a motion for a favorable with the amendment. Is everyone okay being reported in the affirmative? All right, Senate Bill 698 passes with the amendments unanimously. All right, we're going to go on to Shamari again with Senate Bill 758.
Senate Bill 758 is an emergency bill that alters statutory provisions authorizing a cooperative housing corporation, condominium, or homeowners association to regulate the display of candidate or proposition signs by limiting the display of signs to a specified time period. Subject to existing provisions, the bill authorizes common ownership communities to limit the display to a period beginning no earlier than 45 days before the start of early voting, or if early voting is not conducted, no earlier than 45 days before the primary, general, or vote on the proposition.
There's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 758 passes unanimously. We're going to go down to Senate Bill 760.
Senate Bill 760 repeals a requirement that a printed deed or other instrument offered for recordation include certain margins, and 2, requires a clerk of the court to date each change or correction made to information in the general alphabetical index on the horizontal line on which the change or correction was made. Yes.
How long are these?
In perpetuity.
Yeah, this needs, all right, the motions were favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 760 passes unanimous. Senate Bill 162.
Senate Bill 162 expands eligibility for sentencing relief available under provisions enacted under the Juvenile Restoration Act. Under current law, an individual who wishes to file a motion for a sentence and reduction under JRA must have been sentenced for the offense before October 1st, 2021. The bill removes the sentencing date limitation. There are no amendments in your voting packet.
Actually, let me, go ahead, Senator West.
This was an anomaly. We passed the bill clean out of the Senate, went over to the House. Luke Clippinger intended to pass a different bill dealing with a different parole system for these particular juveniles sentenced after October 1st, 2021. He never got around to doing that. So, but this anomaly was put into this bill. What it means in practical terms, just to give you an example. A 17-year-old and an 18-year-old get in the car and go to rob a house. 17-year-old's the driver, the 18-year-old goes in the house to rob the house. Person in the house, turns out there is a person, he dies. So the 18-year-old's prosecuted for murder, the 17-year-old for felony murder. They both get sentenced, they both go to jail. Under the current law, with this anomaly, the 17-year-old is never permitted to apply under the Juvenile Restoration Act to get out. The 18-year-old can apply after 20 years in jail. That makes no sense. I've never heard anyone who could give me a logical reason why this anomaly is in the statute, other than Luke intended to do another bill and never got around to it. So this just clarifies the statute and takes the anomaly out.
Is everyone okay being recorded in the affirmative? Okay. All right, yep. Yep, the bill passes unanimously. All right. This one, yeah, I want to make it. So let's go to Senate Bill, Josh, this is Senate Bill 310.
Senate Bill 310 prohibits the Maryland Judiciary case search from referring in any way to the existence of records relating to an alleged violation of the Maryland vehicle law or any other traffic law, ordinance, or regulation by a minor.
You want me to do it? Yeah. I like the idea a lot, but I just want to make sure we understand what we're doing. Yeah.
I like this idea a lot, and I want to make sure we know what we're doing as well. So the traffic laws includes some pretty big stuff, including DUIs and reckless driving, which can be pretty aggressive. No one who does something like this as a kid should have that on their record, you know, in their late 20s or getting a job in their 30s. We need to clear these records. And the senator who presented the bill is exactly right. And the gentleman who came, who still has this thing on his record, absolutely should get it cleared. The question is, for me, is only how CDLs and other licensures are determined. So this bill just takes it off a case search. It doesn't expunge it. But my understanding is that if you're a private company for a CDL, for example, you're getting it off of privately run criminal background checks. Interstate CDLs are at 18. Interstate CDLs are at 21. So let's say you get 3 drunk drivings at 17 and then turn 18 and apply for CDL, I just want to make sure we don't accidentally clear that person's record in a way that the CDL license, for example, is not accidentally erased. You can become a police officer at 21. I think those are done through public databases, so the expungement wouldn't apply. But I just want to make sure we're not accidentally messing something up on this.
Thank you, Mr. Chair. So I want to be sure that, I mean, I appreciate the words from my colleague, and this is just about the judiciary case search, basically shielding their name and date of birth. It doesn't alleviate them, and this doesn't change anything. If someone is a juvenile, and here's the odd part, if they get arrested for, if a juvenile gets pulled over for, I don't know, speeding, but they've got a handgun in the seat next to them, the handgun violation is going to be shielded as it is, and in their juvenile record, it's all shielded. But the actual offense is not, you know, the speeding. So I just think that why are we looking? This isn't creating a new loop that they get to get away with something. There's still accountability. It's still in their juvenile record. It's still in these things. You know, whether or not I agree with an arrestable offense that should or shouldn't be, you know, available for public review, I think it should still be eligible to be researched by those employers if they, you know, through whatever database. But this is just a shield, so somebody can't go in, you know, do my kid's name or someone else's kid's name just randomly in judiciary case search, and poof, it pops up a driving offense, and then it has their name, their date of birth, where they live, all this other sensitive location, which is nobody else's business. So with that, I think that the bill is very simple, it's very tailored, very narrowly, and I think that we should move the bill as it sits.
I agree with Senator Folden. Happens. My only question is the nomenclature used in the bill. Our court system has these like 3 different operating systems where they have judiciary case search, which is the most public facing, and then the MDEC portal with the Maryland electronic court system, and then they have the Odyssey portal where you can look at records and then also look at the documents corresponding to those records if you're a party to the action. And then if you're in the courthouse, you can use the Odyssey portal to look at all the public documents as well. Is the intent to only shield just judiciary case search, or is it to kind of mask the public access to those records in all of the ways? And I hope at some point, in speaking with Chief Judge Morrissey, they do intend at some point to get to a more aggregated system where you don't have to go searching in 3 or 4 different places, but right now you do. And I think it says just judiciary case search, and maybe that was the sponsor's intention, but I just wanted to ask that.
Or open to everybody to be able to get to from their
Okay.
phone
Got
or
it.
residence, whereas someone that's usually utilizing the court systems is there for attorney or other type of specified tailored circumstances.
Perfect. Then I still agree with Senator Folden. Thank you.
Easy, here comes the big one.
Wheezy.
Is like the judiciary's public website that might be slightly more appropriate, and I think captures case search.
To a stylistic change by DLS to make sure that that's the right word.
It's a good point. She's saying they just change the name.
Yeah, that's what he's saying.
Yeah.
How do you all feel about, I mean, just given the concerns, I mean, I think it's a good bill, but I kind of narrowly tailor what offenses, but I mean, Senator Folden, you brought up a good point. It's just a big policy choice. I just want to make sure that we're just thinking about it.
We're not talking about that overwhelmingly.
Senators, no, can you get Senator Folden?
I mean, we're not talking about overwhelming, like arrests or aggravated assaults or things of that nature. We're talking about where they were speeding or they had done something, run a stop sign. And it could be drunk driving. It could be other offenses, and they would still be able to find those through their background investigation. It's not shielding it from that. It's just shielding it from everyday citizens going and getting access to this information and making it a big production potentially and harassing the kids, doxing the kids. So I would request to move the bill.
Second.
Yeah, that's right.
All right. All right, we don't need, oh, that is a good dad joke. All right, so apparently we don't need the stylistic change. We can roll the bill clean. So there's been a motion for favorable. It's been seconded. Is everyone okay?
Yep.
All right.
Senate Bill 230 establishes that it is a third-degree sexual offense to engage in sexual contact with another person without the other person's consent in connection with a burglary in the first, second, or third degree. A person who conspires to, attempts to, or commits this offense is a Tier 1 sex offender if the victim is not a minor, a Tier 2 sex offender if the victim is a minor who is at least age 13, or a Tier 3 sex offender if the victim is a minor who is younger than age 13. The bill applies prospectively to acts committed on or after October 1st, 2026. And there are no amendments in your voting packet.
Lisa Jordan is here. Lisa, do you want to quickly explain this bill? It's a little complicated. Go.
Thank you, Senator. So the sex crimes law is kind of structured. You have rape, and then you have rape 1, which is rape plus something. You have the same similar structure. You have 4th-degree sex offense, then you have 3rd-degree sex offense, which is sexual contact plus something. Burglary is in the going from rape 2 to rape 1, but it is omitted from going from sex offense 4 to sex offense 3. And sadly, this is a thing. Like, burglars go into people's homes and touch them in various ways. So that just, it both is kind of consistent logically and also punishes people who are touching people in the course of a burglary appropriately. It's only certain burglaries, so it's, you know, it's there's the higher tier burglaries.
Of burglary in the 3rd degree sex and 4th degree sex offense. This just makes the statute consistent.
If the act that we're now trying to codify happens now, what is it?
If it happens right now, it's a 4th degree sex offense. And that's why the registry provisions don't actually change at all for adults. The registry will become a little bit more severe for people who touch either 13 to 17-year-olds or people under 13, but right now it's a 4th degree sex offense. So that's a misdemeanor.
And that's essentially the end goal, is you want people registered who do this?
Well, I think the end goal is also to provide survivors with the response from the community that this is a serious sex offense. It's also probably important to know that burglary merges into the 3rd degree sex offense, so there's no piling on of charges.
Thank you.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay being reported in the affirmative? Okay. Senate Bill 230 passes unanimously. All right, so Senate Bill 512.
Senate Bill 512 alters existing penalties for stalking if a person committed the act, and either the person had an interim, temporary, or final protective order in effect against the person at the time of the offense in which the victim was the petitioner. 2, the person had a court order in effect against that person at the time of the offense prohibiting stalking involving the victim. 3, the person has a previous conviction in this state for stalking. Or 4, the person has a previous conviction under the laws of another state that would constitute a crime of stalking if committed in Maryland. Violator who engages in stalking under these circumstances is guilty of a felony and subject to imprisonment for up to 10 years and/or a $10,000 maximum fine. Under existing law, stalking is a misdemeanor, which is punishable by imprisonment for up to 5 years and/or a $5,000 maximum fine.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay being reported in the affirmative? Okay. Senate Bill 512 passes unanimously. All right. All right. Washington County is the. Shamari for 573, we have a letter? Just
Yes.
confirm. Okay, let's do 573.
Senate Bill 573 requires in Charles County only, each member of a board of directors or officer of a council of unit owners of a condominium and each member of a governing body of a homeowners association to successfully complete a training curriculum on the responsibilities of being a member or an officer within specified timeframes. There is a delegation letter in your packet.
All right, there's a motion for favorable. It's been seconded. All right, is everyone okay being recorded in the affirmative? All right. Okay, aye, that's right, you got it. 573 passes unanimously. Senate Bill 285.
Senate Bill 285 expands eligibility for the Maryland Police Officers and Probation Agent Scholarship Program to include correctional officers and renames the program accordingly. Correctional officers would be subject to the same eligibility and service requirements established under current law for police officers and probation agents.
So motions for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 285 passes unanimously. Senate Bill 694.
Senate Bill 694 establishes that filing a complaint with the Maryland Commission on Civil Rights satisfies specified prerequisites to commencing a civil action alleging the violation of a discriminatory act prohibited by the county code in Baltimore, Howard, Montgomery, and Prince George's counties.
So, all right, motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right. Passes unanimously. We're now going to go on to Senator Waldstreicher with Senate Bill 346.
Senate Bill 346 authorizes an aggrieved party to bring an action against an individual who, under color of law, deprives the aggrieved party or causes or allows the aggrieved party to be deprived of a right, a privilege, or an immunity secured by the U.S. Constitution. The bill specifies that the type of relief available and authorizes a court to award reasonable attorney's fees and costs. The statute of limitations for a cause of action is 3 years after the cause of action accrues. The bill only applies to any civil action pending on the bill's October 1st, 2026 effective date. There is an amendment in your packet. Amendment 1 adds a definition of covered officer. Covered officer means an officer who may make an arrest with or without a warrant for violations of the United States Code and carry firearms in the performance of the officer's duty. Covered officer does not include a law enforcement officer as defined in Section 1-101 of the Public Safety Article, acting under the authority of a joint task force that primarily enforces the United States Code. Amendment number 2 deletes Maryland Declaration of Rights and Maryland Constitution and laws of Maryland from the definition of law under the bill. It adds the Attorney General as a party that can bring an action against a covered officer. It makes corresponding changes. It extends the limitations of a civil action under the subtitle from 3 to 5 years, and it adds a severability provision.
I know there's going to be some discussion. We'll move the amendment. Is everyone okay with that? All right. Now the bill's before you as amended. Discussion. Or 6. Senator West.
Thank you. I frankly have not had a chance to digest the amendment, which is extensive. I came into this session convinced that the bill is unconstitutional. I still think it's unconstitutional. I'm not going to make a stink here, but I will make a statement on the floor after I've taken the weekend to examine the amendment and see how the bill's been changed. Thank you.
There's a motion for a favorable. It's been seconded. Roll call.
Sorry. I just wanted some brief explanation of the amendments, please, because obviously you tightened it up and jettisoned some language that you thought was important, and now you're not doing it.
So the amendments primarily conform it to the House version. The House version is tighter than the original version and limit the applicability of the bill more closely. And the only differences from the House version are some kind of wordsmithing issues and some clarity related to joint task forces.
What was that last sentence you said?
Clarity related to joint task forces.
Okay.
Which means that our folks will be in the federal government.
Right.
Is this the bill where we have the guy that, so, I guess where I'm, couple of things, the covered officers may be where I need some clarification, most, because just saying it conforms to the House doesn't tell me, answer the question of what do the amendments do and why.
I'm happy to clarify whatever you want to clarify. I didn't mean to move quickly. But covered officer is the officer, the officers that are covered under the auspices of the bill. And then it makes clear that it does, covered officer does not include joint task forces.
Is that what when you're referring to section 1-101, is that what that is?
Yeah, 1-101 is the full list of Maryland law enforcement officers. And then a covered officer is a subset of that. And then, so covered officer does not include a law enforcement officer as defined by 1-101, acting under the authority of the Joint Task Force that primarily enforces the United States Code. That amendment was at the request of the Attorney General.
Okay, you're talking so softly. So
I'm sorry,
basically, the one thing you want to say is covered officer has, we have a big description of them in that statute, and you want to clarify just that one particular covered officer. Is that what you're saying? That one particular officer that is on a joint task force?
That's correct.
Okay, and just give me one more second on that.
Take your time.
That makes sense? That makes
I can
sense.
speak up too.
We're on a roll call, but we're addressing questions. No, take your time, take your time.
This section,
I'm also going to give Attorney General's opinion.
this section. Hang up.
You want 4 more? 4 more. 4 more.
If you're comfortable, could you, in non-lawyerly speak,
Yeah.
just give me a sense of what, you said you're trying to tighten the, I mean, I remember, this is a weighty issue that we did not learn in law school. I didn't learn in law school. And so I understand we've tightened it. Can you just, in layman's terms, describe to me what you think we've done with the bill, sort of different? Because remember, he was highlighting a gap that had never really been tested before, because in the early days of the country, we would go under common law and so on and so forth. I remember all that. What I don't understand is any of the amendments and how you think it may have changed the bill.
Sure.
Thanks.
Yep. So I guess I would start with this point. The House rewrote the bill not to change the substance of the bill. It just took, the House rewrote the bill to be kind of more elegant in its drafting and more clearly aligned with what the professor was saying. So I wouldn't say that, I appreciate that you think that there's been substantial changes.
I don't know.
And there have been when it appears to drafting, but conceptually the bill remains the same. We've learned, as we've researched this issue, how to better express the concept that I expressed and that Professor Amar in wording. And we work with the Attorney General's office and the second floor and our wonderful counsel to find that wording. So, so I don't think there's a lot of substantive change in it.
Okay.
And I think we just rewrote the bill to better express what we were trying to do. And that's what you have in front of you.
And did you have a law professor also look at this language, and additionally, the second part is, and the Attorney General look at the language, and then do we have anything in writing from either of those people, the expert and our own state lawyer, giving us some feedback on the bill as the amended bill?
Yep, good question. So I didn't have Professor Amar specifically look at the language. This is my law professor to my right.
It doesn't matter if you did. I just wanted to know if you did. I don't think he would be dispositive in any way, but he is.
I agree.
He claims he is an expert to some degree nationally.
Yep, and so I have worked closely with the Office of the Attorney General on the language that is in front of you. For the record, I was working with the Office of the Attorney General, the policy shop of the Office of the Attorney General to get this language correctly.
Okay.
As you know, we get our opinions from a separate representative of the
Yeah.
Attorney General, with whom, I can get informal communication on that.
Did we get an Attorney General's opinion initially, that would, because since it's not really being changed, at least we hope so. We get into a court of law, you find out your change has a lot more substance than you realize, but we're trying to make it more elegant, read better, whatever, but did we get so not subsidy, so the original Attorney General opinion, if there had been one generated, would probably apply to the bill now, even if it's improved writing. Did we get one from the Attorney General that gave us any guidance in this area?
So the original concerns issued by the Office of the Attorney General are addressed in the amendment. And so, but just to be clear, that came from the Office of the Attorney General as opposed to the General Assembly's Assistant Attorney General.
So did we
Yep.
get, right, and so did we loop that office in any way now to say, we read your thoughts, and our amendments do address them? Or you might say to me, that's not what we listened to those thoughts, but that's not what these amendments did in any event, so no point in going back and asking the Office of the Attorney General to respond.
Yes, good question. I have, just for definitiveness, I have circled back with the Office of the Attorney General.
Yes.
And these amendments address their concerns
Does address the concerns we got.
that they expressed originally in their letter. Yep.
Thank you very much.
I do have a question, but now that I see what happened, that we've eliminated all of Maryland law here, and it's only relates to violations of the U.S. Constitution and U.S. law. How does this interface with the Federal Tort Claims Act?
What did you say? What was the last one, Chris?
How does this interface with the Federal Tort Claims Act, which is a federal statute, which delimits the sort of cases that can be brought against federal officers for violation of federal law?
Good question. Thank you.
Do you think they didn't answer that? The answer is it'll litigate, but
It'll what?
it'll litigate. That question will litigate.
Oh,
But yeah.
okay, so it's your impression that this is contrary to the Federal Tort Claims Act, and the question is,
No, I
can
didn't-
Maryland,
I didn't express that it's contrary to the federal court.
well,
I think
it's inconsistent with.
No, I'm sorry. When I said it'll litigate, I think that'll be a question that the court will ask and help determine when this bill litigates, yeah.
Thank you.
Thank you. Sorry. Thank you, Mr. Chairman. On 346, did we have any weigh-in from any concerns from the local governments did they express any concerns? Thank you. I didn't think so. Thank you.
Thank you, Mr. Chair. Due to the weight of this and the language changes that we've seen this morning, especially about covered officers, I'd like to hold it, at least to be able to review this and look at because, we're putting in covered officer and how this affects certain actions under the color of law. So with that, I would like to ask to hold it to be able to review that a little further in detail. Please.
Things on the list left. I mean, we've made a pretty good dent here. I don't want to come back after the floor, so I do not want to come back after the floor. The bells have rung, so we got to get going. So if you're asking to hold, let's hold till Tuesday. It'll be the first thing we take up on Tuesday. This bill will be 346 will be the first bill on Tuesday. I do not want to come back after floor unless you all want to finish this out. All right, all right. So Tuesday, stand by for a time. I'll announce it on the floor. All right.